When is a guardianship needed for an adult? Hi, I'm Guy DiMartino. I'm a Northwest Indiana estate planning lawyer, and I'm going to give you a factual scenario which we see commonly when it comes to guardianships for adults. Received a phone call this week from a loving granddaughter. The granddaughter said, "My grandfather fell, broke his hip, was in the hospital, and now grandpa needs to go to a long-term skilled facility, a nursing care for rehab, but because of his mental issues, because of his loss of capacity, because of his dementia, he's probably going to need long-term skilled nursing care or a nursing home." She said he was so stubborn in his life that he never did any documents to go ahead and deal with these issues. And the hospital is telling me that a guardianship is going to need to be set up in order to handle his affairs. So what is a guardianship? A guardianship is a procedure in which the court appoints one or more persons to be a guardian over an individual, over the person, and or the estate of that person, the stuff that they have. So there's a guardianship over the person, it's a guardianship over the estate. And what the guardian will be able to do, if they're a guardian over the person, is help manage the person's personal affairs. And that might be putting him into a nursing home, getting him the proper medical care. And if the guardian is also the guardian over the estate, they can write checks, they can handle the estate affairs. So this is what needs to happen. You need to file a petition with the court. You need to put medical evidence before the court to show that the ward or the incapacitated person cannot handle his or her own affairs. And then the court will appoint a guardian with something called letters of guardianship. And the guardian will have the legal authority to act on, in this case, grandpa's behalf. Cost money. You got to file a court matter. You got to go to court. You need to provide medical evidence. Many times the court will accept a specific type of letter from the treating physicians. If you're a guardian over the estate, you're going to have accounting duties that you're going to have to provide to the court. And there's a simple way to have avoided all this stuff. When grandpa was in his right mind and able to make his own decisions, he could have delegated this authority, number one, with a durable power of attorney that would have given his granddaughter the ability to handle his business and personal affairs, and also appointing a healthcare representative or a healthcare power of attorney, or having advance directive documents, whatever you want to call it, giving somebody the legal authority to act on his behalf if he was unable to do so. If granddaughter had that document, granddaughter would be able to talk to the doctors. Granddaughter would be able to put him in a nursing home. Granddaughter would be able to help manage his healthcare affairs. And if granddaughter also had the power of attorney, she'd be able to pay his bills. She'd be able to deal with Medicare or Medicaid or things along those lines. Those two simple documents could have resolved this whole issue that is going to happen now. If you have any questions regarding a guardianship for an older person, you can always reach out to us. I am Guy DiMartino. Have a great day.